Okay, we're going to start. I'm going to start with PSI on our journal entry. I know we got that in a different order, but all of our updated forms are on the website that you see there. If you have carpal tunnel or anything like that this morning and don't want to highlight the journal entries, be advised that we do have them on the website, and they are highlighted just like what you're going to see this morning. And so we're going to go over what the new changes are in the journal entries in the PSI. But first, why journal entries? Why do we do these things? We've been doing them now for ages and ages. We started out with the fact that, some of you can remember when the journal entry was a prose document and was pages and pages of paragraphs, and you had to hunt and peck for actually what exactly happened in the case. As time went on, and I think it was Judge Johnson's idea, probably. It actually came out to the form that it is right now. And each of those are fields that are filled in that we use to place in our database. And it also, more importantly though, it's a proof of sentencing. It's our documentation of what happened at that particular time for that time, but also for historical purposes, so that you as PSI writers, as prosecutors, as a defense counsel, and as the court can actually look back and see what exactly happened. In some cases, law enforcement need these for transporting or detaining as well. And if you're unfortunate enough to be a victim of a property crime, your insurance company would like those as well. But again, for the Commission's purpose, these are all things that affect what we actually do on a daily basis, whether we're actually doing pure research or whether we're doing that in a legislative capacity, for the annual report, or for those prison projections. We even keep track of, for example, probation violations, sending those journal entries in. So for example, here, we actually even keep track of missing journal entries. For those of you that I'm sure are aware, when you have a probation violation, the statute requires you to send that journal entry in, but it also requires criminal history worksheet as well as the PSI, as well as the original journal entry. This just shows you where Johnson County falls in the top 3 as far as missing journal entries. And I think in this case, Sedgwick County is always the biggest offender, but keep that in mind that they have about a quarter of our crimes in the state as well. So I think about 22.6% is what Sedgwick County carries for the entire state. So they're certainly going to have more journal entries as well. But that just kind of gives you an idea of we even track some of those metrics in terms of, so as far as submitting those, that's very important for us because we archive on a yearly basis. And so if you have a probation violation that occurs several years later, it takes a whole lot of time when if you just had a copy of the original journal entry, we could easily pull that back up. Okay, we're going to start with PSI first. One of the things that we found that was that we wanted to, my goal is again to try and make this as painless as possible. And one of the things we were running into, we're getting a lot of calls as to, well, which one journal entry am I supposed to use? Because we work off of a fiscal year rather than a calendar year, which ones am I supposed to use? We've changed the heading now so that we have, you can specifically know on the PSI and the journal entry of sentence just exactly whenever the crime was committed. Most of your journal entries are, well, all of your journal entries are offense-based. So whenever that offense was committed, that's what journal entry you're going to use. We've made it easier now so that you know July 1 through June 30th of next year this is the journal entry or the PSI you're supposed to be using. Most of you are also aware of the fact that a couple of years ago we changed our drug grid. We went to a 5-level system. And as a result, we also had a double whammy, and we went to a quantity-based system as well. And so in that respect, one of the requests that have been made is trying to figure out just exactly what type of drug offenses we're dealing with. The triple whammy was the recodification back in 2011, that while it was a great idea, and that now we have things like battery and aggravated battery are all in one statute, we have turned into a subsection nightmare. And again, that's one of those things that trying to remember, fill out a journal entry on the fly, depending on whether you're in court or however you do that, it turns into a very big struggle. And so one of the things, again, we wanted to try and do, if at all possible, for journal entry of sentence as well as here, is all we're looking for is what schedule, under 4105, Schedule 1, 2, 3, 4, 5, what the name of the drug is, and if it was a sale or distribution, how much was it? What was the quantity or the amount? And keep in mind the amount meaning just how much it was. If it was 50 grams, it was pled down to 30. 30 is your amount that whatever they were convicted of is what you're going to actually be including in there. So that makes it easier. What we're looking for in the name of the drug: meth, coke, marijuana, those type of things, so that we can actually, again, those are all fields that we can put in there so that we can actually later on be able to tell you in your jurisdiction how many coke convictions you had, how many meth convictions you had, and then as a statewide situation as well. Yes, Jeff? Not necessarily. His question is sometimes they don't get all of the documentation. Is that what you're saying?
Well, we don't necessarily know the exact amount.
Okay.
In fact, I don't see, even when they reduce it, like what is now a 3, or a 2 to a 3, many times that's not even changed in the complaint document, charging document. So we will not really know exactly what the amount is supposed to be.
How do you know if it's not in the charging document? How do you know what they pled to then?
Well, typically in the affidavit, there'll be a range that will be mentioned that this sale was between this amount and this amount, or had this many between this many plants and that many plants.
Right. Well, our ideal situation is if there is a specific amount, that is the ideal. But if you're just looking at a severity level, which we know that severity level has a range itself that you're aware of, then you're just going to have to do the best you can with what you have. But I can tell you that what our specific request has been for the exact amount that is actually pled to. If for some reason you do just plead to a 3, then that's obviously all you're going to be able to do, and presumably that's what's going to happen on the journal entry as well of sentencing. Okay. All right. This particular one, the post-release, again, this is actually just a reminder. Again, as we know, you should not be checking this box for an offense that actually occurs after July 1. So essentially, you'll see this throughout the journal entry. We'll probably take that off next year, but this is just to remind you that it's not going to be applicable for this. So this should never, ever be marked. The DUI, this is an occasion where the Sentencing Commission does make mistakes, and we do miss things. And this has been in law for several years now, and 1567C actually allows the court to give a 1-month enhanced penalty if you've got a child that's under 14 in the vehicle at the time of the offense. So keep in mind that's probably going to have to be in the factual basis on the plea or in the complaint, I would imagine. But that actually is, and I didn't put a jail term in there because, as you know, the court can impose other things other than jail sanctions to a DUI. So, and that's actually the language of the statute is an enhanced penalty, but it's a mandatory 1 month if that's actually part of the factual basis. Page 2 and 3 are just your supplements or your supplemental pages. Those are going to be the exact same that we did on the face sheet, and those have the drug again. They have the no post release and the DUI provisions. Okay, on page 5 of the PSI, these are new. Well, the first actually, the DUI fine, apparently there was issues with the clerk's office in getting the funds from DUI to the Community Corrections Supervision Fund. And so this is a gentle reminder in the cost section to, and the checkbox there as to that $250 being sent to that fund. As a result of legislation this year in the human trafficking arena, there is a human trafficking victim assistance fund that has actually been created that the Attorney General administers. This is to essentially cover the entire program or the cost of the program, and that it is anticipated that the Johns are essentially going to fund this program. And so this is what the other, any fine of $2,500 to $5,000 is sent to that particular victim assistance fund. Page 6 of the PSI. Is special rule pages, and I'll go over this in just a second. There was a change in the law, Senate Bill 58, that talks about trying to clear up manufacturing a meth case and when the special rule applies. We just added language there to make sure if the previous conviction is for meth or its analog, then it's presumed prison. But there was some confusion. I will tell you that there was even confusion among the legislators as to, number one, what the law says or said, and what they were actually passing. So if you feel confused after reading, I think I've got it on slide 40, and I actually made a table for you that hopefully will be helpful as to when that special rule applies. But it was confusing to the legislators as well, so don't feel too bad. Special Rule 40 is what we were talking about before. Felony committed after early discharge when the offender would have been on probation or post-release supervision for a felony. So keep that in mind that that is now available and in play. And the question, of course, is what was raised already, and that was how are you actually going to know about that? For journal entry purposes, we do have a section back in the criminal history worksheet that we'll check on in just a second. That felony test refusal, because that was a technical cleanup, it is now with the non-grids. Last year, you may or may not have been aware, it was a severity level 10 felony. Because of it was left out of a subsection, it wasn't listed as a non-grid, and so we actually had it up here under 37 because just the way it was characterized, and that was an oversight. But it's been changed now. Nothing else has changed on felony test refusal. They've just made sure that it's now your non-drug or your non-grid. And keep in mind, those are the only ones: the felony DUI, felony test refusal, your domestic battery, and the animal cruelty are your non-grid felony offenses that you're going to see. This next slide is the one I was talking about, the Senate Bill 58, that is, I think it's on your slide 40, but this just kind of goes over to cover that Special Rule 12, just exactly when it applies. But keep in mind, this is just for manufacturing offenses. All right, page 7 of the PSI. This is offender registration, and the involuntary manslaughter provision is the only one that is not available here is A3. You notice that A1, 2, and 4 are in there. A3 deals with in commission of DUI or in flight of DUI. And so that particular provision is not included in the involuntary manslaughter provision that, for registration. Buying sexual relations was part of the human trafficking bill. A lot of the, we'll get to that in just a second, but a lot of the names have changed as far as patronizing a prostitute, selling sexual relations, buying sexual relations, those type of things that the language has actually changed, but not the elements of the offense. At the bottom of the page, commercial sexual exploitation is of a child is a new offense in human trafficking land. It was done, my understanding, primarily because to try and take care of the girls that were under 18, and so the punishments are harsher. In fact, the Jessica's Law-like in terms of mandatory minimums 25 and hard 40 are available for those folks. Okay, page 8 on the PSI is what we were talking about, the early discharge provision. We've added the early discharge segment in there. Again, this is all highlighted on the website as well, but it goes over to give you an idea of where that's coming from, and so it just provides the extra there to reflect the change in the statute.